Thank you. I'm Fred Rajala, and I've been with the Department of Ecology since 1983. I've worked in our Yakima office, I've worked in our headquarters office, and I'm physically located in Spokane at this time. And there's the correct spelling of my name. It's spelled two different ways, I noticed, in the material that you were handed out. And I'm really here representing all those people that you're likely to talk to if you contact one of our regional offices at the Department of Ecology, the people who would get a well log for you or research a water right, the people who process an application, make decisions on those applications and tentative determinations regarding water rights, draft certificates of water rights, and all those little functions that really make the machinery of this particular branch of government work. I hope to talk about some water right principles, but Steve North hit a lot of those, as did other people. The elements of a water right, something about water right processing and changing water rights. I didn't prepare a slide on water conservancy boards, but I do that. I've been training water conservancy boards since 1998. One thing we have to keep in mind that makes our work more complex is we don't have the whole picture. We don't even have all the water right records. There are water rights out there, such as those held by Native Americans that we don't know about. They're not adjudicated, they're not defined, but we have to recognize they're out there. They treated water as a feature of the land, and they used it, but they didn't have the sort of property interest held by the individual tribal members that we consider as a foundation of our water rights system. Also, we have these old doctrines, riparian, appropriative, abandonment, that we have to deal with too, that aren't really part of the water code, but they're part of what we deal with in terms of water management. And this is my own definition of what a water right is. And Steve North mentioned that there isn't a good definition in law, because water rights are so varied. We use water in so many ways, and everybody is dependent on it. But every water right is, first of all, a beneficial use of water. And then from that, you can ask, well, how much water do you need in order to accomplish that beneficial use? And when do you use it? And where do you use it? What's the source of water? And all those questions that help you characterize what that beneficial use and what that water right contains. A key thing, if someone comes to me and asks, do I need a water right to do this? What I usually consider first is, are they using water to the exclusion of others? You don't need to hold a water right in order to swim, to boat, to fish, or make beneficial use of water in all those ways that are held in common. But it's when you're using it to the exclusion of others. That's my first test as to whether or not you're liable to need to hold a water right of some form in order to accomplish your purpose. So beneficial use, we have a statute, and this is part of the Water Resources Act of 1971, 9054-020 sub 1, lists a whole lot of activities, all the obvious ones of domestic supply, irrigation, stock water, but other things too, in-stream values, for example, aesthetic purposes, and declares them all to be beneficial, or at least declares them to be purposes, beneficial purposes. But I think the key thing is, at the end it says, and other water uses compatible with the enjoyment of public waters are declared to be beneficial uses. And I think this is important because the way we use water today is different than when the water code was written in 1917, which, by the way, this is the 90th anniversary, June 8th, 2007, so make your party plans early. But at any rate, You know, we have something like 140 certificates on file for the filling of steam locomotives. And there still are a few around, but for the most part, that's an archaic use. People aren't doing that. But then we have other uses coming on, like the misting of fruit in orchards is a relatively new purpose that has been invented for water, and they all require water rights. So this language allows the water code to be dynamic and change as public needs change. Grimes defined the beneficial uses being two things. It's a purpose for which you use water, and the quantity of water that's reasonably necessary in order to accomplish that purpose. So the elements of a water right we typically work with are the purpose of use, the source of water, the amount of water, the place of use, the period of use, and then generally of less concern to ecology is the seniority. It's more important to the water right holder because for most of our activities, most of our decisions, we can't impair any water right, regardless of the priority. So for most of our management purposes, we're respecting all rights. Oh, I was going to, yeah, would I clarify QI, QA, and I was going to get to that in another slide. So purpose is the manner, and this first bullet is really paraphrasing what's in statute. And it doesn't have to be of economic value, though many are. It doesn't have to be consumptive or non-consumptive. It can be either. And it can be in-stream or out-of-stream. So it's very flexible. And I just want to hit municipal purpose as well, because this new law, I think it's 2003 or so, defines a municipal purpose where you are serving 15 or more connections or a residential population of 25 people or more for 60 days. And then governmental purposes, you know, if you're a municipality, a PUD, or these other things, and I think there's about 6 specifically named, then you are a municipal. So source of water is two things in my mind. The source of water is the water body from which you take water, but it's also the point at which you take water. And sometimes you'll see that point just called out as though it's separate. But in my mind, the two are closely associated, especially with groundwater, where you can't take that well and move it to a different body of groundwater. You have to stay in the same body. So there's a very close association between the point and the water body itself. Water quantity. Water quantity we describe in two ways, but as I said, it's reasonably necessary water to accomplish the beneficial purpose. And reasonable necessity is a case-by-case determination. The amount of water you need to irrigate corn in Yakima is different than what you'd need in Colville, for example. And what's reasonable, you know, you can irrigate some crops through a drip system, and other crops you really have to flood irrigate, for example. We quantify water a couple ways. We characterize it in terms of how much you're entitled to take at any point in time, and that's QI, which stands for instantaneous quantity. And this we describe it for groundwater as gallons per minute, and for surface water as cubic feet per second. And then QA is the annual quantity, and we characterize that as acre feet per year. An acre foot is enough water to cover an acre of land a foot high. So period of use, obviously that part of the year that you can beneficially accomplish the purpose. So for irrigation, it's almost always seasonal, but for a domestic supply, it's much more likely to be year-round. But it doesn't have to be. We have seasonal cabins, for example, not even accessible in the winter, so they're seasonal domestic supplies. And place of use, it's only the area that actually benefits from your use of water. So though you may have a water right document that describes 40 acres, but if you're only irrigating 10, then those specific 10 acres that you historically irrigated is where that water right exists, regardless of how broad the description is. Date of priority, as I say, that's not as important to ecology as it may to be to the right holder, unless we are for some reason regulating those rights. And generally, we will only regulate where those rights have been determined through an adjudication, because the courts are the ones that address priority. And after an adjudication, we can regulate. And in general, we simply don't impair any right. So the way in which priority is determined can vary. And I don't know that this slide is exactly right. There's a lot of nuance to this sort of thing. So in general, though the way in which priority is determined depends in part on the nature of the establishment of that right. And certainly if your right is established through an application, then the statute says the date of filing the application becomes your priority date. Water rights can have conditions, and these may or may not be specifically identified on the water right document. For one thing, standby and reserve, alternate, and additive versus non-additive have to do with the way in which that water right relates to other water rights, the way you use them, the reason you established it. If you had a water right and you established another one because you needed more water throughout the year, then it may be additive. But on the other hand, if you established it simply because you needed to pump more at any given point in time, then only the instantaneous rate might be additive and the annual rate may not, because you didn't need more water throughout the year. You just more or less needed peaking flows. So in addition to these, there are other sorts of conditions. Typically we'll put well construction conditions or screening conditions. And even if your right doesn't have them, there are laws on the books that says if you go in and reconstruct your well, you have to meet well construction standards. There's a few that are associated with the nature of the use. For example, the Family Farm Water Act says that after 1977, if you perfected a Family Farm Water Act, you had to continue to comply with the definition of a family farm, with some exception. And we have to consider the consumptive nature versus the non-consumptive nature of water rights, especially when we're looking at water right changes, and how can you modify it, and how will the new proposed water right, how's that compatible with the water right that you're proposing to change, and how will that modification impact other rights? Well, if it's non-consumptive, if there's some element of water that returns for use by others, then we'll look at that. But consumptive water rights are generally the water evaporated, transpired, water that results in a product like bottled water. Magically, you put it in a bottle and it becomes a product. And non-consumptive water often represents the water that's necessary in order to accomplish the beneficial use, but it really is the inefficiency associated with the system. For example, to irrigate a crop, you may have to apply more water than can be held in the root zone. Some of it percolates deeper and escapes, and that would very well be return flows. This little diagram is just to give you an idea of what we deal with. There's listed at the top and with the vertical lines 5 different statutes. Well, yeah, 5 different statutes, plus we have all the pre-1917 issues. And then the horizontal line is kind of things that those statutes initiated or somehow affected. Pre-1917, you had custom, you had postings, you had the riparian doctrine, appropriative doctrine, you had a lot of things going on. 1917, you had the permit system. 1932, according to the courts, if you hadn't exercised your riparian right, then you no longer had the ability to do that. So riparian rights were more or less cut off. They'd either become appropriative rights because you put them to use, or they were cut off. So we deal with a lot of different laws, and timing becomes very important. We have to explore the history of what law was in effect when a certain event happened. This particular graph kind of highlights changes in those 2 boxes and some of the considerations for those. So we end up, as a result, with a number of different water right documents, and Joe Storr surprised me in saying how many there were. I forget the exact number, 4 million different documents, something like that. But the ones we deal with most of the time are certificates of water right, permits, which a permit is an authority to establish a water right through beneficial use, and typically will result in a certificate. Certificates of change. More recently, when we've approved a change, we'll reissue the certificate. But there are those rights that aren't documented by a certificate that we can reissue. And in the distant past, they also simply issued certificates of change. So any change to a water right where we don't already have a certificate that we can reissue gets documented by a certificate of change. Then water right claims, which are assertions to the existence of a water right. And that last slide, I don't know if you noticed, there have been 4 different periods where one could file a water right claim, those broken lines in the lower right. So 4 different periods. Those forms were different. The criteria and the manner in which you filed those claims varied, but they all potentially are assertions of the existence of a water right, and they represent their potential water rights. Oh, and also, I might add, we look at permit exempt groundwater uses as well, and typically our information about those is contained in our well logs, because there's a little box you can check where you would identify that the well you're drilling is for permit exempt groundwater uses. Some water rights, as I mentioned, aren't documented by a water right document at all. So our water right permit system, I think it's really interesting because each file is like a book. It's a history of the development of a water right. And each of these phases in its development is like a chapter. And you have to read the whole book to really understand that water right. You can't jump to the last chapter, which would be the certificate, and assume you know it because you've read the certificate. You have to read the whole book. And I have, my second handout is some examples of some of these documents. But you file an application. I consider the public notice to be part of the investigation phase because we ask for comments and concerns. And that's part of our investigation to determine whether or not it will pass those 4 tests which were mentioned to you. Are they proposing a beneficial use? Will the use impair the rights of others? Is there water available? And is the use, or the proposal anyway, contrary to the public interest? So our application for permit, as I mentioned, the date of filing that establishes the priority date of the right. And Steve went through a list of what's contained within the application itself. The word example is here because it relates to my other documents, where if I trusted the technology, I could leap to those documents and right here show you an application, but we'll just hold off on that. Public notice and investigation. Our investigations have become very complex. It always includes at least one visit to the site, possibly more. All our regional offices have hydrogeologists who study what the potential impacts are, aerial photos, research into our other records, and often can require investigations by the applicant as well. The example I have is really much simpler than that. But our reports of examination, which pretty soon we're going to start posting on the internet, so you'll be able to see what they look like. But they're probably averaging 8 to 10 legal-size pages to explain what our findings are and our conclusions. So the permit is, as mentioned earlier today, it's sort of like a building permit. It's the authorization to go out and develop something. In this instance, you're developing a water use. And by establishing that water use, then in compliance with the permit, you, as the developer, develop the water right, establish the water right. In the example I'll show you, the permit was actually page 4 of the application form. And all they did was simply endorse the application, mark whatever modifications they wanted on the application form, but endorse the application, and the application itself became the permit. Now it's a separate document where we restate and clarify exactly what it is that permit allows and what it requires. There's a development schedule on every permit, and that's negotiable. We're supposed to establish a development schedule that allows for reasonable development. And if that can't be met, then extensions are possible as well. If you can show us that you've been using good faith and reasonable diligence in developing that permit. So the water right is developed through actual use under the permit. So we probably have, well, I know we have water rights out there that are still only represented by the permit that allowed them to be established. And then when we can, and it's become more complex too, because in the distant past, we used a form called a proof of appropriation, and that was considered satisfactory evidence that someone had actually developed a water right, that we would issue the certificate. Well, so many of those are extremely inaccurate because the information provided on the proof of appropriation form was inaccurate, that anymore we take a second look just so that we know what we are documenting in our certificate actually reflects the right that was established. Now, our certificate's really a historic document. The water right's been accomplished. You had the permit, and you put water to beneficial use in compliance with the permit, and all we're doing is certifying that that's been accomplished. So the certificate doesn't grant a water right. It merely documents that a water right's been established. And there's a question earlier about development. I think the question might have related to when a certificate issues or when you're complete. I forget exactly, but you're complete when you report to us that you're complete up to the limits of that permit. So if we issue it for 10 connections and you report that you've accomplished 7 and you're done, then we'll be prepared to issue that certificate. Water right claims. We've only had a permit system for surface water since 1917 and for groundwater since 1945. So there were a lot of water uses that were already in place and established prior to our permit system coming into effect. Well, for years, we really didn't know where those water rights were, yet we were supposed to determine that there would not be impairment to those rights when we issued new permits. And of course, that wasn't such a problem when there's less water uses and less population as a whole, but certainly it became a growing problem as time went on. So in 1967, a law was adopted that said between 1969 and 1974, if you had a water right, a right to divert or withdraw water that was not represented by a state-issued permit or certificate, that you had to file a water right claim. And the claim merely asserts that a water right exists. It's not in itself evidence of a water right. It's an assertion saying, I have a water right. So, yeah, I believe I have a water right. So in total, there's been 4 different filing periods because beyond the original filing period, they opened it up 3 different times, giving people as much opportunity as possible to record these documents as they could. The penalty for failing to record that water right claim was you were considered to have waived or relinquished your water right. Either file this claim or give up your water right. There is an amendment authority as well within the department, a special form. If you find an error in a water right claim, then it's possible to amend it.
Is there any consequence of those who fail to respond to a current update on quantity or something?
If people had failed to file or failed to respond to an update regarding quantity on those claims, yeah.
Like a 10-year follow-up or something after this file as quantity now?
I don't think there's been any formal statewide follow-up. In some basins, especially related to watershed planning, we are sending out inquiries to try to get a better definition of whether or not those assertions are still being asserted and to what extent there's use. But there isn't a statewide formal process called for. So adjudication, you have these water rights that some may not be documented by any paper within the water right record, and that would include a lot of stock watering, federal rights, tribal rights. You have water rights documented by certificates and water rights documented by water right claims. In the 1917 law, the original text of the law, it was recognized, basically they recognized 3 things: that we needed to have an organized way to establish new rights, and that's why we have a permit system. We needed to have the authority to regulate those rights, so we do have regulatory authority. And the third thing was we need to figure out who already has water rights. And so they developed an adjudication system. And an adjudication is conducted by a superior court. And ecology is the one to file that case, but oftentimes we're responding by petitions filed by water right holders requesting that an adjudication occur. There's been about 82 adjudications throughout the state, but only 5 in western Washington. The closest to you here is the Dungeness, which was adjudicated back about 1924. Problem with some of the old adjudications is we weren't legally able to include tribal and federal rights because we didn't have that authority until 1953, I think it was, with the McCarran Amendment, which is a federal act that allows states to include federal and tribal rights if we're generally adjudicating water rights within an area. We have a list of a number of places where adjudications have been requested, including the Colville River Watershed Planning Unit has requested that the Colville River be adjudicated. We're also looking at while we're talking to local government, local citizens about whether or not it'd be worthwhile to adjudicate some of the streams in eastern Washington that flow from Idaho, such as the Pend Oreille, the Palouse, the Snake River, because Idaho is going to adjudicate their side in the Panhandle. So if there were a water dispute and their rights are adjudicated and confirmed by a court, but ours are not, perhaps we'd be at a disadvantage in any kind of interstate dispute or settlement. So we don't know if that'll happen. We're just trying to, communicate and organize our water right documents right now over there. But so I guess, like the Dungeness, I just want to emphasize, it's not a very comprehensive adjudication because it was pre the McCarran Amendment. We still don't know what the tribal rights are, for example, or even for the Olympic National Park or the forest up there. So we can change water rights documented by water rights certificates, certificates of change, or water right claims. And in general, we're changing water rights that are perfected. That's not exclusive. As Steve mentioned, you can change the place of use and the location of your well for groundwater permits, for example. There's a few other instances where you can make changes, but in general, you perfect the water right, you put it to use, you see an opportunity to do something better, and you propose a change. So we can change that well location or point of diversion. We can change the place on which you're using water. We can change the purpose of use. And in the R.D. Merrill decision, the Supreme Court recognized that we can change the season of use, at least when we're changing the purpose. I think it was so tied to a change in purpose that I don't think you could say, well, if you're changing the place, you can change the season. So in general, if you change the purpose, you can change the period of use. And then you can add uses, or you can add irrigated acres. And Steve went through the calculation of annual consumptive quantity, which is a special calculation that really only applies if what you're proposing falls under that last bullet. Otherwise, we can look at the totality of the right. And that's the first step we have to take, is we have to decide, is there a water right? And what is the extent of that water right? Because we can't change something we can't define. And then once we define it, then we have to consider whether or not that will impair the rights of others. And if it's groundwater, we basically, for groundwater, the law says you have the same considerations as if you were issuing a permit. So really, you're looking at the four-part test. So the concept of a water right it's based on history and tradition. It's based on established practice. It's adopted through statute and case law, and to some degree just custom. I mean, there's things that are out there that we take for granted, that you can't find a specific line in statute, or perhaps even a specific line in case law. But, we've been at this for 80 years, 80 plus, almost 90 years. We have a way, a custom, and a procedure that's been adopted that had to rely on more than just the letter of the law. They're confirmed through an adjudication, which most rights haven't been adjudicated, so there's this until we have to touch them for some reason. There remains this question as to what is the extent of that right. But the whole system is flexible to allow for changes in societal needs, changes in purposes of use and the like. So that's the end of this presentation. I actually have another presentation that's to walk through some water right documents, because we've talked about water right claims, but I hate to leave here and you not have seen one.
How many of you have seen a water right official document? Where did you get it? In an assessor file? Okay, who else have it? Where do you see? Where'd you get your hands on it?
What is now Thin River.
It's now been marked, okay? Any others?
Owners provided
Good.
Well, I think really the best source for water right documents is the Department of Ecology, because certificates get recorded at the county, but all the background paper doesn't. And also, we have tried to maintain information about the connections between one water right and another water right. So if you pull this one, then in the background there's data that says, oh, well, if you're looking at that one, you better look at this one also. But the best way to research water rights through the Department of Ecology is by the point that you're taking water. If you know where the well or the diversion point is, then we can find that most easily, because that's the way we've organized our water rights. Secondarily, you can use the location of the property, and that's fine if the point they're taking water isn't some distant point with a long canal or something. Another way is through the applicant's name, but in this example, for instance, and I apologize, some of this may be hard to read, but I think it's F.A. Rotter. Yeah, it's in your handout. F.A. Rotter, and the certificate didn't actually issue in his name. Another way you can do it is by the certificate number, and that will help us. We can do that, but the number used within our computer base is a standardized number that's not based on the certificate number. It's based on the application number. And the reason for that is every file began with an application, but not every application resulted in a permit, and not every permit resulted in a certificate. So the one number we could predict was there was going to be an application number. So, and here's the front page of an old application. This is from the 1920s. The application number isn't even on this particular page. What you have at the top is a permit number. And it's hard to read, but that's permit number 896. And what they did is, every time they issued a permit, they gave it just a consecutive number. So the first permit issued was number 1, the second one was number 2, so on. Well, that's the same thing they did with applications, is the first application in the door was number 1, the second one was number 2. Well, the first application didn't necessarily result in the first permit. So there's no good connection between the application number, the permit number, or the certificate number, because some people would develop quicker than others. So, yeah, so what we had to do is standardize it for our database with a number we call the control number, which, we use to control the data, and that's based on the original application number. So this particular application, it has the information that Steve had mentioned that you need to have, F.A. Rotter, and he was in Stevens County, Northport, wanted water from Gillette Creek, and you'll see that first circle, it says he was proposing 1 cubic foot per second, and then parentheses it says allowed 0.6 CFS. And the reason for that is, as I mentioned, the last page of the application was endorsed to become the permit. And the whole application, in essence, became the permit. And they'd simply type things in there to distinguish between what was proposed and what was actually being permitted. Of course, one problem with this is you can have other notations on there too, and it's not very readable, but in the upper left corner you'll see someone's handwritten something on there. So we don't know, is that part of the permit or is that part of the application? So it becomes sort of hard to interpret these things. He's proposing the irrigation of 50 acres, and he describes an area. That second circle identifies the time of year, because he's proposing both domestic and irrigation purposes. So he wants the domestic purpose continuously and the irrigation purpose from May 1st to November 1st. Hang on a second. Wanted to get my bigger copy so I didn't have to keep turning around. The next circle is the point of diversion that he's proposing. This is surface water, so we refer to that as a diversion. We refer to the use of groundwater as a withdrawal. But anyway, its exact location isn't so important, except it's on there. And this is simply, again, just his proposal, but it gives us something to work with. In the second page, there's various information that was important at the time, such as canal system, which we typically don't put on our applications anymore because less people are using canals and gravity flow, and much more it's electric and pump systems. But item number 11 describes what he's actually proposing, and I guess it says about 30 acres. But he describes 3 quarter sections, which, a quarter is what? It's 40 acres. So he's describing 120 acres, but saying that he only wants to irrigate 30 acres. Number 11, water duty. This one isn't complete, but this is pretty useful too, because after describing the character of the soil, it will identify annual precipitation, and then it says depth of irrigation water required, which is real useful because typically in inches they would identify how much water they needed over the season, which is a pretty good indicator of how much water they would use on an annual basis, because these old documents don't specify that. So this is often the best information we have. The third page of this particular one is probably less important, but I included it anyway because numbers 15 through 18 identify the process I'm on the wrong document. Number 14 identifies or asks you what you'd need if you were looking for a municipal water supply. I'm sorry, this isn't the document that describes the process. So we have the application, and next begins the investigation, and that's going to, at some point, include a public notice. And within our file, you should find an affidavit of public notice. So this is evidence from the publisher that we actually did publish, and gives the dates on which that publication took place. And this is something we require to be submitted back to us by the applicant, because we'll prepare the public notice, but it's up to the applicant to actually get it published. And then we require this form be submitted back to us. This particular file included a lot of letters because, anymore we would go out, we would do a lot of field work. There'd be field notes, there'd be aerial photos, and all this other stuff that in the 1920s they weren't doing. So there's a series of correspondence back and forth. And this upper circle, this applicant's confirming that he had a survey made and describing where the intake is. So this is a point you ought to be able to rely on because it's been surveyed. And then he also points out that there are grade stakes that have been placed where the ditch would run. So this is obviously a ditch that's going to be near contour, slightly downhill so water flows. But if you went out there and you knew where the starting point was, you ought to be able to look at, well, what's just about on grade and be able to follow the ditch. Whether it exists or not, you'd know where it might have been. This particular letter I pulled because it has a map. And so this is perhaps a better description of where he actually intended to use water. Remember, he filed an application for 30 acres, yet he described an area of 120 acres. So looking through the file, you can find maps and better information about where that actually would be. In this letter, dated 1927, so this was filed in 1922, and I think these are in order. I don't think the permit had issued yet. So here he says, I estimate that approximately 30 acres of the 50 acres is irrigated under the new right. The entire 50 is so situated that it can be irrigated under the new right. But then he goes on, talking about the new right versus the old ditch in the second to the last paragraph. So this is an indication that, whoa, maybe there's another water right associated with this land. Even though he's filed this application, he's got something else here. So this would tell me to start searching our records regarding that property. What else is there? You won't find it anywhere else in this file than simply in these correspondence. This next letter, also 1927, what I've circled is the description of the land I irrigated under the new ditch is as follows. And he describes exactly what lands he's going to irrigate under the new lands. So you have a map and you have this description that tells you much more precisely what lands benefited from this water right. Because after all, the water right attaches to the lands. And then he included another sketch which shows his new flume and his old flume, and then the course of Gillette Creek, which was the water source. So that old flume would suggest there's another water right. The new flume tells you, well, the land's irrigated, this is gravity flow, and because I know the lay of the land land's benefited is the lands between the new flume and the old flume. Here was advice from the department to Mr. Rotter. It says, I think it advisable that your application be amended to cover 30 acres rather than the 50. So the application we looked at only said 30, but in fact it was changed from 50. For the reason that you could retain a priority of 30 years for the land covered by your original ditch, while your priority under the application would date from March 17th, 1922, and so on about in the event of an adjudication. This could be important. So So there definitely seemed to have been some other right, and we were suggesting you may want to preserve that old right. And where you see the word back is where I would have jumped back to my other presentation, by the way. So finally, the permit issues. And the permit also issued in 1927, so it took 5 years from the filing of the application to the issuance of a permit. So, you know, we may take a long time now, but it's been a process that's always been kind of on the understaffed side. Oh, okay. Okay. So included here is a development schedule, and the application itself was modified to be the permit. And on this page, just above the word permit on the left-hand side is the actual application number. So you have to look this far to find it. At the bottom, this is the one on the bottom. It will describe the steps that were used, which are roughly the steps used today in establishing a water right. Oh, so I'll run through these quickly, but we have a number of forms that have to do with development where people report things. The first one, which I think it'll leap back to, is a notice of beginning of construction, followed by the notice of completion of construction. And these particular forms in this file aren't that interesting, but in many files, they document a lot of information that might be real important in understanding how it was developed and when it was developed and even what the intention of the permit holder was. And then here's the proof of appropriation of water. We still use this form, but anymore when we receive it, we go out and take a second look. At this time, they were simply mailed to Olympia, and no one took a second look. What I've circled here is for what purpose is water needed. And you'll recall the application was for domestic supply and irrigation. Well, the only thing he reported that he developed was irrigation, and then that was of 30 acres in size. And still he's describing a very large area. At the bottom is the time of year that water would be used, which is somewhat different than he proposed in his application. I think the application said May 1 to November 1, and now he's reporting use as early as April. So this is the certificate. If you just looked at the certificate, this is all you'd see, and it would be a 30-acre area of irrigation within a 120-acre parcel, and it would say domestic supply and irrigation. Well, you know, there's some question about the domestic supply. Maybe he developed it and didn't report it. Maybe he never developed it. I don't know. And this is what the property looks like today, or at least in the year 2006. And the red box, hopefully that's visible, is the northwest quarter. So he's talking about three quarters of that quarter, roughly the area that's cleared, I think. But I don't see flumes. I doubt there's still flumes. Maybe he's gone to a pipe system, and so that probably affects the amount of water he actually needs. It looks kind of green. It's hard to say, you know, might be a time of year thing. Just quickly through two more documents. Here's a water right claim. We have roughly 170,000 water right claims on file, and they don't all look like this, but probably 90% of them, well, maybe 80% of them look like this. This is the long form that was used in the original filing period. This one's kind of interesting because they said they're using 20 gallons per minute, 241 acre feet per year, which I don't think you can pump that much at the rate of 20 gallons per minute. And even at that, he's saying he's irrigating 1,657,100 acres, which, you know, that's a big piece of property. And yet, where I usually start looking at these is number 7, where it lists purposes: domestic and irrigation of lawn, garden, and animals. So that's, I don't know. I mean, you know, there may be a valid right represented by this claim, but I'd say the claim has a few sort of obvious errors in it. Some are better than others. In this box in the lower portion is the water right claim number. So it's always a 6-digit number. This one's 112358. And I'm running out of time, but the next document is simply our certificate of adjudicated water right. Sometimes it'll say so at the top, but it always will in that first paragraph cite the case from which this certificate issued. So that's maybe the most obvious clue. What I circled here is that it again says water that's reasonably necessary to accomplish the purpose, limited to not more than, and then they'll have a quantity.